Hi and welcome back. So today we'll look at admissions in law, the informal and formal admissions, the conditions of admissions, and here of course what they are, and also look at statements which amount to admissions in the law of evidence in Kenya. So here we start. So what is an admission? An admission is a statement, oral or documentary, which suggests any inference as to a fact in issue or relevant fact, and which is made by any of the persons and in the circumstances here, in the circumstances that will be mentioned below. So an admission is a statement that somebody says, okay, which is relevant to the facts in issue or the questions that are posed in a case in the court, okay, which a court needs to determine in order to arrive at a decision. So an admission is a previous statement or representation by one of the parties to the case that is adverse to their interest in the outcome of the proceeding. So we already see the elements that are coming up in a statement which qualifies as admission. The statement has to be working against, okay, the party who is making it. It amounts to a concession or voluntary acknowledgement made by a party or someone identified with him. So it is something that somebody says they have done, and this has to be, we see another element here, voluntary. So it cannot be forced or coerced out of the person who is making it. It has to be a voluntary statement that is made without any undue influence. Its amounts, yeah, we say this. So this person will make a voluntary statement, which is an acknowledgement of something that pertains to the facts in issue before a court, okay, in a proceeding, and that statement is contrary to the interest. It's acting against the interest of the person who is making it. So those are the elements you would want to look at when you are deciding whether a statement is indeed an admission or not. So these statements, which qualify the elements of being made voluntarily without any force, being contrary to the interests of the person who is making them, and being a statement that is acknowledging a fact in issue pending before a court, okay, they amount to evidence, okay. Why? Because when they are made, they tend to prove or disprove any fact or conclusion. So that is the nature of an admission. It acts as evidence. All right, and the final most notable element of these admissions or statements is the fact that they are binding. Once they are made, the person who is making them is bound by them. All right. The discussion of admission in this session covers admissions in civil proceedings, but it is important to distinguish admissions in the criminal and civil context. And then there's also the difference between admissions and confessions. So it's we'll look at this. We'll just mention the distinguishing characteristics. So here we have the discussion. Admission in this section covers admissions and confessions. We have admissions, confessions, and admissions in criminal and civil context. So what are confessions? Confessions are statements which amount to admissions of actual guilt of the crime in question. That was mentioned in the case of Republic versus Lee, a 1950 case. In the context of criminal proceedings, Justice Coldry in Hazim versus the Queen stated, a 1993 case stated that the accepted distinction between confessions and admissions is that the former involve admissions of actual guilt of the crime. So confessions means admissions to the actual guilt of the crime, whereas the latter, which is admissions, relates to key facts which tend to prove the guilt of the accused of such crime. So confessions, I would say, are more direct. They go to, for example, if an accused, says that they indeed killed somebody, so that is a direct, it's an actual admission of the guilt of the crime, okay, that they have indeed killed the victim. Whereas the latter, admissions relate to key facts which tend to prove the guilt of the accused. So I believe admissions are more uh, of what do you call, they're more like scattered facts that when somebody admits or when somebody makes them, acknowledges them having been made, they lead finally to proving the guilt of the crime. Whereas confessions is the destination, okay, it's already there, it has proved the guilt of the crime. Admissions are acknowledgements of facts which will lead to prove the guilt, okay. So admissions are more like the formula to get there, and confessions is the solution. It's already done. Now, admissions are broadly classified into two categories. A, we have judicial admissions, and B, we have extrajudicial admissions. All right, so we already are talking about categories of admissions, judicial and extrajudicial. Before even reading, I would just like to say this, excuse me, is looking like we have admissions that are made before a magistrate or a judge in a court of law, and extrajudicial admissions that are made maybe outside the court. But let's just see. So judicial admissions are formal admissions made by a party during the proceedings of the case. So if anybody makes statements in a court of law during the session, when the court is in session, and says that or acknowledges some facts which are contrary to his own interests, and those facts are relevant to the facts in issue, okay, this amounts to judicial admissions, because they are being made in during the proceedings when the case is going on in court. Extrajudicial admissions are informal admissions not appearing on the record of the case. So these ones are informal. Judicial admissions being made in the case are fully binding on the party that makes themselves. So whoever utters a statement of acknowledgement, acknowledging any fact relevant to the question in the case, and that is contrary to their interest during a proceeding of the case, this will be binding on them, okay. They constitute they constitute a waiver of proof. So whoever makes these admissions, judicial admissions, okay, will be bound by them, and they have a nature of waiving the need or necessity for proof. So they remove the necessity to prove the facts that they have acknowledged. So it's no longer required that it needs to be proved. They can be made the foundation of the rights of the parties. All right, formal admissions are distinct from informal admissions in a number of respects. For example, informal admissions are usually made out of court, although they can be made in formal settings, even to a magistrate, for example, okay? That, however, does not make them formal. Formal admissions, on the other hand, are usually made as part of the pleadings. So formal admissions, or what we call judicial admissions, are admissions that are made during the proceedings of the case. Not only that, they are made also as part of the pleading. So they are on the record. They will be preserved in the pleadings, all right, of that case. Pleadings are, we know what they are. Pleadings refer to the necessary documents you file in court for a case, so they will be on record. That is the nature of formal or judicial admissions. On the other hand, so informal admissions constitute merely an item of evidence helping to prove the other party's case, whereas a formal admission, once made, is conclusive proof of the fact admitted. So I believe judicial, and from this statement, I'm getting that judicial or formal admissions are those which somebody takes an initiative to and goes before the court to make them formally in the pleadings that they have filed in court. So they'll be on record and they will be binding this person or party who's making them. Whereas informal admissions are consequential, like when somebody makes a statement, all right, or when an item of evidence comes up and that item of evidence will prove the party that is against you, will prove their case. So it's almost like incidental or consequential, whereas formal or judicial admissions are those that are intentional. You decide you want to make this, and they even form part of the documents you file in court, all right. The weight to be accorded to an informal admission depends on the circumstances. So the weight that has to be on informal admission depends on it makes sense, because even its nature is circumstantial, like it's incidental. Formal admissions cannot be withdrawn or contradicted without compliance with certain formalities. All right. Why? Because their nature is binding and they form part of the pleadings. So anything that forms part of the pleadings, obviously, there's a whole process in civil procedure of how you can withdraw or amend those pleadings. Formal admissions need to be clear and unequivocal because of their implications. So they cannot be ambiguous. They have to be, if they are pleaded, of course, they form part of the pleadings. They need to be clear and unequivocal, of course, like anything else you plead in court. All right, excuse me. Some ASMR. Okay, so we move on to formal admissions. Formal admissions are a form of proof since they absolve a party who would otherwise have the burden of proving them, okay? We say this, their nature is to waive the necessity to prove the point that is being made, okay? The existence of the fact in question is taken to be conclusively established, and even evidence that would tend to prove it now becomes inadmissible. So even if there was evidence that would have otherwise been presented to prove that the fact that is being admitted, it will no longer be admissible because it has no point. It becomes useless. Now, formal admissions are binding on the party admitting, and he will not be allowed to contradict. So you cannot contradict what you have admitted in a formal admission. In civil trials, formal admissions may be made during pleadings. We say that when when you're filing your documents, those are referred to pleadings in court, you whatever the document is whether it's a plain, so that admission will be forming part of them. So they are pleaded, okay, or during the trial itself. So it can be made in the pleadings on record or during the trial itself, maybe as a way of somebody acknowledging personally. Okay, it's not necessary for a party to prove a fact formally admitted, nor is it competent to disprove a fact so admitted. So we already said this, it's simply repetition. Now, withdrawal of formal admission is only possible in the event of compliance. We say this with formalities under the civil procedure. The court will only allow withdrawal if satisfied that it was a mistake. So where it was a bona fide mistake, it was an honest mistake, then it will be done. It's possible to withdraw, and that there is no prejudice to opposing party. All right. So unless the statement, if withdrawn, would not prejudice or disadvantage the opposite party, or yeah, or have it was made as a bona fide or innocent mistake, then those two reasons are the ones that are required when you want to withdraw a formal or judicial admission. The party seeking withdrawal must give a full and satisfactory explanation for the withdrawal, supported by evidence like an affidavit. Yeah. So when you want to withdraw formal admission, you need an affidavit. You swear that you are withdrawing. It will state obviously the reason why you are withdrawing, and of course it will state if it's an innocent mistake, that will be indicated, and the court now will be left to see whether or not by withdrawing the formal admission it will prejudice the opposing party. Okay, now even after withdrawal, a formal admission may still be taken into account as an item of evidence. It may still constitute an informal admission otherwise. So the nature of a formal or judicial admission is very weighty. Okay, it has a lot of weight. Even when you have withdrawn it, the opposing counsel can still be referring to it. Okay, the fact that you made this once can have an effect, okay, on your case, and it's also acts like an informal admission, so it can still be referred to the fact that you made it once. Yeah, it can affect maybe the weight of anything in the contrary that you say later. For example, if your admission was the fact that you have a habit of stealing, and the case before the court is about, the question is whether you stole the bag, okay, from the complainant. So, and then you withdraw that. Once you withdraw that, once you withdraw, okay, the prosecution can still be referring to it, the fact that you once made it. So if you were to say later that you have never stolen anything in your life before, obviously the court will be raising eyebrows. Okay. Now, in criminal trials, either side, the defense or prosecution, may make formal admissions in favor of the other side. Withdrawal of a formal admission in criminal trial is possible if the formalities have been complied with, but a withdrawn admission may still have some evidentiary value. That's what we've been saying. It doesn't just disappear. It can still be referred to. Okay, there's a need for clarity. Formal admission should be worded and recorded carefully. We say this to eliminate ambiguity. A formal admission would not necessarily be in writing, so it doesn't have to be in writing, but this is preferable for the purposes of clarity. If there is any ambiguity, the general principle is that the interpretation in the accused's favor is to be applied. So it is the accused here in a criminal trial who is going to make this formal admission. At least that is the case in this book. So the accused who makes this admission, okay, it's generally advisable for them to make it in writing just to be sure of that the conditions of clarity and preciseness have been met. Okay. If it turns out that the admission is ambiguous, all right, you can't tell the beginning from the end. The general principle is that it will be interpreted in the person's favor, the one who is making it. A plea of guilty constitutes a type of formal admission. So, a plea of guilty is also a formal admission. So when the accused is pleading guilty, as they have done something, they have committed the crime, it constitutes a formal admission. Once the plea of guilty is altered to one of not guilty under the Criminal Procedure Code, okay, of Kenya, any admissions already made and not affected by the alteration stand as proof. They are unaffected or unchanged by the conversion of plea to one of not guilty. So you can see how serious formal admissions are. Even when somebody is pleading guilty, an accused pleads guilty, okay, in a court of law, and later changes the plea of guilty to not guilty, which is allowed, by the way. So if that happens, if they once made a formal admission to plead their guilty state of mind, that admission remains unchanged, but the plea can change. So it's kind of like it's like a two in one kind of. So it remains, yeah. All right, that is it on formal admissions. All we need to know is that it's a serious thing, and withdrawing it requires sufficient reasons and requires a form of evidence, like a supporting affidavit. Uh, the person must give an explanation and the reasons that can convince the court are innocent mistake and it should not prejudice the opposing party. Formal admissions can be pleaded in the pleadings, so they can go on record. They can either be in writing or they can be made orally, but it's advisable for them to be made in writing, just so it can be sure they are clear and not ambiguous. And where in the case we have ambiguous ones, they will be interpreted in the person who is making them, in the favor of the person who is making them, who is normally the accused person. So we also saw a type of admission is a plea of guilty, but if the accused makes an admission to plead guilty, but then changes his plea from guilty to not guilty later in the case, in the criminal case, it will not affect that formal admission. And that is why we say formal admissions are serious in nature. So we move on now to informal admissions. Informal admissions, we said in the beginning, in introduction, is that they are incidental, all right? You could have said something and acknowledged, okay, outside the court or inside it, or can be before magistrate, and it comes or it becomes an informal admission. So they are made but without court proceedings in mind and may therefore be withdrawn when convenient. So the process of withdrawing them is kind of easy, okay? You can withdraw them. Unlike formal admissions, however, they are binding only partially and not fully, except in cases where they operate as or have the effect of estoppel, in which case, again, they are fully binding. All right, so while formal admissions are binding on the parties making them, and they will not be allowed to contradict it, but they can be allowed to withdraw it under certain conditions. These informal admissions are only binding partially, okay, and except in the case of estoppel, where once you have made this informal admission, you are stopped from claiming anything to the contrary. Now, the requirement for the admissibility of informal admissions in civil cases is relevance. So, the fact that you're acknowledging has to be relevant to the case or the questions before a court, okay, in that case. Additionally, where statements are made in the course of settlement negotiations, they may not be received without the consent of the party making them. That was decided in the case of Naidu versus Marine and Trade Insurance Company Limited, 1978. It's a South African case, if I'm not wrong. So, relevance, whatever the person is admitting as an informal admission, the fact has to be relevant to the questions before a court in that case, okay? Additionally, where statements are made in the course of settlement. So where people make informal admissions when they are settling out of court, yeah, when they're deciding to settle a case before it goes to court, all right, they may not be received unless the consent of the party who made them is obtained. So the court will not receive them unless the consent is obtained. And who will consent to what they have admitted during out of court negotiations? They can't. It will prejudice them. And that is why most people, when they are agreeing or when they're trying to settle out of court, the lawyers normally write the correspondences without prejudice, and we'll look at that at the end, which means that they cannot be received as evidence in court. So the requirements for admissibility in criminal cases are that the statement be relevant and that it must have been made voluntarily. We say that for a fact, for an acknowledgement made by a person to amount to an informal admission, it must be relevant to the case, and it also must have been made voluntarily, of course, like as is the case for all admissions. It cannot have been forced out of the person. Admissions may be made verbally or in writing, or they may be inferred from conduct, or in any combination of these ways. So it can, just like formal admissions, it can also be verbally or in writing, or they may be inferred from conduct. So it can also be implied. That is why I'm saying sometimes you don't intend to make an informal admission. You don't come out and stand up to make it intentionally. It can be incidental to something you have said or connected to a fact you have already acknowledged. So it can be implied from conduct as well. So it's kind of incidental. All right. Admissions may be made verbally or in writing, okay? Or they may be inferred from, why am I repeating? Sorry. Admissions may arise by conduct such as silence, failure to answer letters. Okay, so this is they're giving situations where it can be implied. It can be implied from silence. When you have been asked a question, and you keep quiet because there's this. Is it an assumption that silence means presumption? Silence means consent, something like that. Like you consent to what is said. So silence and failure to answer letters. In the case of silence, common sense may indicate that the silence is in effect an admission of an accusation. So if somebody accuses you and you keep silent, it is implied that you have done what you're accused of. That was in the case of Jacobs versus Henning, a 1927 case. Okay, so this fact of silence is also it's also put against Article 50 of the Constitution of Kenya, which is the the article where the rights of accused persons are being explained or provided for. So Article 50, Sub-Article 2. Article 50, Sub-Article 2, that was the right of, the rights of an accused person to a fair trial, okay? So I think that is the right to be presumed innocent unless proven guilty. So even if they keep silent, it is weighed against the fundamental right of an accused person, so to a fair trial. Now, in the case of failure to answer letters, the court will not assertedly conclude that failure to respond to a letter is an admission by silence, as in the case of a failure to deny orally. Surrounding circumstances must permit a reasonable inference. So when it comes to implying that somebody admitted something through silence or their conduct, the court will not just readily come up with those conclusions. They will look at the surrounding circumstances. All right. All right. So that is that. Now, okay, so we have also under informal admissions an interesting aspect here of vicarious admissions, where somebody is implicated by an informal admission made against him by somebody else. Okay, these vicarious admissions will be admitted under the following conditions. Okay, number one, where there is implied or express authority to make the admission. So there must be an authority of that person to make the admission in the first place against the person. So where the litigant adopts statement of the third party and ratifies it as his or her own. All right, and where the litigant and a third party shared a privity or identity of interest. So those are the conditions that will permit the admission of vicarious admissions or admissions made by third parties against the person. It's like saying, I had Tom say that he indeed steals from time to time. So that is a vicarious informal admission. You are admitting, you are saying somebody admitted to something, to having done something, okay, which is relevant to the facts in issue in that case. But for those to be admitted in a court of law, because you see, you heard somebody say, so it's hearsay. And in the video, if you haven't watched it, I made about hearsay evidence. It's very important, I discussed in detail. You will understand the conditions that amount to hearsay and statements, and direct evidence is what is required in a court of law. Direct evidence is that the person who is making the statement heard it himself, saw it himself, perceived it himself. It shouldn't have been made by somebody else. It should not have been seen or perceived by somebody else and the third party is narrating it in court. That will amount to hearsay. But also in that video, I talked in depth about the exceptions where somebody where the court can admit hearsay evidence. It's generally not admissible, but there are exceptions, such as when the person who said those things is dead, or when they cannot be found and brought to the court to speak for themselves, or if finding them is very difficult, bringing them to the court is difficult and expensive to the court. Okay, so in a case of dying declaration or some other thing. So you can see this is indeed everything we are saying here and discussing is interlinked. So it's very important to watch the video I made on hearsay evidence, it will help you a lot to understand which type of evidence the court cannot admit and what exceptions exist to admit them. All right. So now that we have seen what formal and informal admissions are, let's go to the next subtopic, which is effect of admissions. What effect do admissions have as evidence in a case? An admission can suggest an inference as to any fact in issue or as to any relevant fact. In both cases, the admission can be used as evidence to prove the fact in issue or the relevant fact. In addition, whenever the admission suggests an inference as to a fact in issue, it can be used for the purpose of determining the burden of proof of that fact. So the burden of proof of a fact in issue is ordinarily determined by reference to the other provisions of the Evidence Act, but there can be cases where an admission of a party may have the effect that even though ordinarily the burden of proof of the fact in issue would be on one party, it may shift to the other party which made the admission on proof of the admission. So you can see this is talking about burden of proof, which is also a video I made. Please watch it, where I explained that who bears the burden of proof in a criminal case and who bears it in a civil case. And in a civil case, the person who bears the burden of proof is the one who alleges, who, if no move has been made, would lose his case. Okay, so if the plaintiff is alleging a fact, he has to prove it, and if the defendant is alleging a fact, he has to prove it. In a criminal trial, the one who bears the burden from beginning to end of the case is the prosecution, and the accused is not required to prove his innocence in any way. That was held in the case of Wilmington versus DPP. Now, if you look closely, we have been told that when an accused person makes an admission, okay, it can shift the burden of proof from the prosecution to the accused in the case where there's a requirement of proof for that admission, okay. Also, the nature of admissions has this unique effect of changing the bearers of burden of proof from the one who would normally bear it to the person who made that statement. Um, so this section declares admission to be relevant and further provides that they may be proved against the person who makes them, okay, or his representative in interest. It would appear that admissions are pieces of original evidence and may be filed as such by a party against his opponent to demolish his opponent's case or to establish his own. They provide inherent evidence of the truth of the facts contained therein. Okay, so for example, in a criminal trial where the accused has made an admission, okay, that the prosecution can actually use that admission to establish or build their case, to determine or to further influence the court to determine the guilty mind of the accused. Okay, so it can be, they are serious in nature. They affect the burden of proof, and they also may be the foundation on which a party can establish their case against another party. Okay. So especially when they are formal admissions, they are very serious. We saw that they are very serious in nature, and they constitute evidence of the highest value. Okay, if they are written and their meaning is clear and unambiguous, clear and certain. So once a formal admission is in this, has satisfied these conditions, Even we saw in criminal trials, even when the accused pleads guilty as as a formal admission and then tries to withdraw it later, or changes his plea from not guilty, okay, from guilty to not guilty, it will not change the formal admission he made about him being guilty. So it's very serious and it has an effect, a very serious effect on the case. And those formal admissions, even if they have been withdrawn, can still be referred to. The fact that you once made those, any statement you make to the contrary is gonna be affected by the admission, even if it doesn't exist, even if you've withdrawn. Yeah, so for example, where someone is suspected of stealing and they make an admission that they they steal from time to time, and normally they wouldn't make that as a formal admission. Let's say if somebody is a suspect is caught for stealing, okay, and they're before an investigative officer, and when their statement is being taken, they mention that they have a habit, like, yes, I have a habit of stealing from time to time, but I did not steal her bag, you see. Okay, I did not steal her bag in this particular time. Okay, I did not. So it's it's it has an effect. Okay, it has an effect of changing the mind, or making the court believe, you see, that they have been made, that that person indeed has could likely have stolen that. So they are very disadvantageous to the person who is making them. Yeah. So so if the prosecution was to use that informal admission you made, okay, that you have a habit of stealing or pickpocketing, and they can use the circumstances, all right, surrounding that informal admission you made, you can likely be, you know, it could likely be the final blow that takes you to yeah, that convinces the court that you stole. Okay, so there are conditions of admissions. The stronger an admission is, and the strength of the admission is affected by the conditions it is made. Okay, the nature it is made, is it written or oral, is it clear or ambiguous, is it made with voluntarily or by force or influence, was it made by mistake or was it made with full intention. Okay, if an admission, the strength of an admission is affected by these conditions, all right. uh, so the more an admission satisfies the conditions of clarity, certainty, um, uh, being written, and what do you call it? Uh, being deliberate, voluntary, all those conditions, it becomes even stronger in its effect. All right. So unless they are challenged, all right, they are presumed to be true, all right, and may by themselves be quite enough to form the substantive basis of a finding of a fact in issue. So they could be powerful enough, okay, if unchallenged, and they could be powerful enough to make the court decide on that, on the admission. Their destructive or constructive tendency is a wide one, and their repercussions cover the entire case. Alright, so that's it on the effect. That's it on the effect. Now, we move to ambiguous admissions. What are ambiguous admissions? We saw that for an admission to have the strength, it needs to be in writing and it needs to be clear and certain. All right, and we saw that those formal or judicial admissions have to be clear and concise. All right, and once they are made like that, it's very hard to to for them to disappear. All right, so let's see what are ambiguous admissions. I will tell you before we even read that this is everything that is against the conditions we have mentioned under formal admissions. All right, it's everything against being clear, so they are unclear and they are confusing and hard to put together. They are probably not in writing, and even if they are, it's not clear. So one thing, however, is important to note in this connection: in order that admissions may have the far-reaching effect of disadvantaging another party, okay, disadvantaging the party who made them, okay, they have to be clear and certain and not vague or ambiguous. We said this, and where the accused, where the admissions have been found to be ambiguous, they will be interpreted in the interest of the person who will be otherwise disadvantaged by them, who is the accused. Okay, so so the judicial or formal admissions or generally admissions have to be very clear. That is the fundamental stone on which they stand, okay, to affect the case, the rest of the case. Reference in this connection might also be made to Corpus Juris Secundum, volume 31, paragraph 277 at page 1029, where under the heading certainty, the law relating to admissions in this regard is stated as follows. So under the juris secundum, an admission should possess the same degree of certainty as would be required in the evidence which it represents. Okay. And hence mere conjectures or suggestions as to what might have happened if certain circumstances had not occurred are not competent. Neither should an alleged admission be considered where the subject matter to which it refers is left uncertain. Yeah. So we see that the requirement that an admission should be clear and concise is very serious. Okay. Yeah. Now, it's not necessary that the statement should be a direct admission. It may be an indirect, or in this case, an informal admission, as where it bears on the issue incidentally or circumstantially. A statement is not competent as an admission where it does not, under a reasonable construction, appear to admit or acknowledge the fact which is sought to be proved by it. We said when we were defining what an admission is, we say that admissions normally are acknowledgements of facts which are relevant to the case or are facts in issue, okay, which would answer a question that is put before the court, okay. So So it wouldn't qualify or amount to an admission where a statement does not admit or acknowledge something, a fact which is relevant to the case, or forms part of the fact in issue or answers it. Although admissions shift onus on the party against whom they are produced. Okay. We said also the nature of admissions is that they shift the burden of proof from the party uh, from the normal bearer of the burden to the party against whom that admission is what do you call, is operating. Okay, so the initial onus of producing admissions and proving that the piece of evidence produces admission in fact and in law lies on the party setting it up. So before the person who wants to rely on an admission against another party, okay, if the prosecution, for example, wants to rely on an admission that the accused made, okay, and they're trying to bring it up, they have to prove, okay, they have to prove that the statement they are relying on is an admission. It has amounted to an admission, okay. So the prosecution will first be required to explain to the court and prove that the statement that the accused made and they're willing to rely on it for their case is indeed an admission. So you'll see that the prosecution would be talking like, okay, an admission, they'll be citing cases where an admission has been defined, what a statement, which statements amount to an admission. They'll be saying these sections of the Evidence Act which defines an admission, and they'll be referring to that statement to qualify it, okay, to prove that it is indeed an admission in fact and then in law. So they will be quoting the circumstance, and also they'll be saying the whole the sections in law which define admissions, just to make sure it qualifies. Okay, excuse me. So they will not only prove that the statement they wish to rely on is indeed an admission, they also have to prove that it is clear and concise and certain, okay, that it is not ambiguous, and where they fail to discharge this burden, that is, in other words, where the prosecution fails to qualify the statement, to prove that the statement is clear, even if after it's been shown that it is an admission, they have proved it's an admission. If they can't prove that it's clear and concise, that they fail to discharge that burden, okay. So there are certain elements here that the prosecution is required to prove before they can rely on a statement as an admission. So this element, let me just note it down. Elements. Number one, the fact that they are an acknowledgement, okay, of a fact that is relevant, or it's relevant to the fact in issue. So it's an acknowledgement. They have to prove that it is an acknowledgement. Number one, they also have to prove uh, they have to prove that it is clear and concise, okay, and they also have to prove that it was made voluntarily, and also that it is unfavorable. Unfavorable to the person who made them. So that is the whole thing. The burden or the onus falls on the one who is wishing to rely. Yeah, and once then they have discharged the burden, the burden now shifts to the person who made, if they have evidence to challenge what was in the admission. All right. Yeah, so the condition of clear and certain is very serious. It's very, very, very serious. For a statement to amount to an admission, it must be clear and concise. That's simple. It must meet other elements, of course, voluntarily made and favorable to the person who is making, and is in its nature an acknowledgement of a fact relevant to the case. So those elements must be present. And we are saying here that one of the most important of those elements to prove is that it is clear and certain. It should not have been misinterpreted by the person as to mean something else who is relying on it, and shocking the person who didn't mean it the way it was, who made it. So the interpretation must be clear. That is why. So if somebody said they have a habit of pickpocketing, and the prosecution interprets it to mean that they indeed during that moment pickpocketed, and once they present that to the court, the accused is like, no, I really didn't mean that when I was saying. I said that I normally, when I'm very hungry and I need food to eat, I pickpocket. But I did not mean that in that particular instance I stole the purse. So you see, there's a conflict of, and that is why it's very important for it to be clear. So you see what I'm saying here. There is a very, very, very high requirement that the statements which are to be relied on as admissions must be clear. So let's look in the Evidence Act, which sections talk about statements that qualify as admissions, okay? Which statements qualify as admissions in the Evidence Act of Kenya? If So under section 18 of the Evidence Act, subsection 1, it says statements made by a party to the proceeding or by an agent to any such party whom the court regards in the circumstances of the case as expressly or impliedly authorized by him to make them are admissions. So where an accused person makes a statement or their lawyer, their defense lawyer makes a statement, okay, which is an acknowledgement of a fact that of a key fact that either he was present during the time the murder took place, okay, in that building, in that complex, in that time, okay, or so those will qualify as an admission, whether he made them or the lawyer or his agent made them. Now, another instance is statements made by parties to suits. Suing or sued in a representative character are not admissions unless they were made while the party making them held that character. So we have types of suits where maybe it's a class action and only okay they authorize one person to act on their behalf, okay, and they're suing or are being sued, all right. So in this case, this person who is making them, okay, who the representative, if they make the statements, they will not be admitted as admissions in the court unless they made them when they were in that role as a representative. So that means the judicial admissions they will make that during the proceedings as in their representative role are likely to be admitted, but the ones that informal they made outside the court before they had the authority to act as a representative, those will not be admitted. So subsection 3 is saying statements made by persons who have any interest in the subject matter of the proceeding, whether money-wise or property-wise, okay, ownership-wise, and who make the statement in the character of persons so interested. So that also amounts to uh, an admission. Persons for whom the parties to a suit have derived their interest in the subject matter of the suit. Admissions if they are made during the continuance of interest of the persons making the statement. So here I will just say that in under subsection 3A, persons who have money interest or property ownership interest, I'll say let's say these are like the owners of a property, okay, the lessors. And then we have number 2, persons from whom the party sources have derived their interest in the site. We can have the lessees, okay. So these are all admissions that is under section 18 of the Evidence Act of Kenya. Now section 18 deals with the relevancy of admission by party to proceedings or his agent, okay, by suitor in representative character, by party interested in subject matter, and for those who have derived an interest. Now, for a statement to amount to an admission in a suit, such statement must have been made by a party to the suit, okay, and must be against his interest, or in the case of an agent to such party to a suit where the court regards such agent to have been authorized. So agents, I told you, agents are people who are authorized to act on the behalf of another person in court. That is your lawyer who is representing you and your case. Whatever statements they make, they will qualify as admissions because they are not making them for themselves, they are acting on your behalf. And your lawyer, I said, and a person who is acting in a representative character, because you have given, in order for a person to act as a representative in a suit, suing or being sued on behalf of the rest of the group, okay, they need to be authorized by you, okay? So whatever they will say, be careful when you are consenting, because it's as if you have said it. So it has been held that evidence of conversation between an advocate's clerk and potential witnesses was not admissible, since there was no admissible evidence that the clerk was acting on the authority of the advocate's client. So you see now there's no nexus or connection. There must be that relationship between the agent and the principal. The principal is you, who is the client, if you are the accused, the defendant, and the uh, agent is the lawyer who is acting. So what about the clerks? The clerk who is working for the lawyer. You have no agreement between you with the clerk. You agreed with the advocate. So whatever the clerk said is not admissible as an admission. And these clerks, whoever works with law or any legal matters or medicine, they are sworn in to be confidential, to keep things confidential. So that's why also it's a lesson for all of us to not disclose client information to anyone if we are working under these fields or these professions. That is also, it falls under the professional ethics of um, working. Being professional means being confidential, all right? So you don't go about and around discussing client business. And the same applies to the people who are working under you, okay? So where the issue, that was a deviation, sorry. Where the issue was proof whether an advocate wrote a letter on behalf of a client, it was held that it was necessary to show that the letter was written on the client's specific instructions. So again, here we see that even in correspondence, when an advocate writes a letter on behalf of a client, it is necessary to show that the client consented or instructed for that person to write that letter. So the content of that letter cannot be relied upon to incriminate the client unless it was consented, okay? It has to be consented by the client. So it's not just a relationship of agent and principal, it goes more than that. It has to be that the agent was acting under instructions by the client, okay? Not just haphazard himself, he just decided to do things by his own authority or his own mind. So that was in the case of Downer, 1880. Now, where in a suit parties sue or are sued in a representative capacity, any statement they make can only give rise to admissions. Okay, so long as such statements are made when they're acting in that role. This is a repetition. We said this, not before or after. So it should be during the time they are acting as a representative in that suit and not before or after. So when such representative steps out of the cloth of representative, they lose capacity, okay, to make any statements which can be relied as admissions, relied on by the opposing party as admissions. So where a person has a recognized interest money-wise or ownership-wise in the subject matter of the suit, let's say that subject matter being a land or property or a house or building, okay? Or another person who derives an interest from such a person, let's say the lessees who are leasing the building, although they not be parties to the suit, such statements as made by them will amount, okay? So even if they are not parties to the suit, whatever statements which qualify as admissions will be admissible in court if made by them, all right? All right, so the following conditions must be satisfied. In order for this to happen, the statements are made by such persons in their character of persons so interested and during the continuance of the interest. So it is as long as that owner remains the owner of that building or property or land, or as long as that lease is still his lease is still active. All right. And another condition is the statement relate to the subject matter of the proceeding. So the statement must be related to the matter that is in question before the court. Now, where a non-party to a suit makes a statement and the issue for the trial court involves a determination of the position of liability, such non-party as against a party to the suit, such statement would, notwithstanding his being non-party, amount to an admission. So where a third party who is not connected to the suit, okay, who is not a party to the suit and holds no interest in the subject matter, but they made a statement, that statement would be admitted in the following situations. Number one, if the non-party had actually been a party, and if the statement had been made while such non-party occupies such position or was subject to such liability. So, okay. Okay, this one is complicated. Let's move on. Where a party to a suit has specifically referred to a non-party for specific information. So whichever statements that the third party makes will, if they amount to admissions, will be admitted in court. So if the accused refers to the principal in that school, for example, the principal is aware that I was away on holiday, so I couldn't be in that building or school when the shooting began or something like that. So if the accused refers to somebody else for information, the whatever statement that third party makes will amount to an admission if it fulfills, of course, the requirements of admission. Now, finally, such statements made by persons from whom the parties to the civil proceeding have derived their interest in the subject matter. We already said these are admissions if they are made during the continuance of the end. So this is a repetition. An admission when made is not necessarily sufficient proof of the fact admitted, but will operate as an estoppel should a party attempt to argue otherwise than the admission. So once a person makes an admission, they are stopped from making some statements contrary to the admission. Okay, but I think they can withdraw them. Just a minute, excuse me. All right, so there is that. All right, so that was all under Section 18 of the Evidence Act. Now, moving on to Section 19. Section 19, then we have Section 20, we have Section 21, and 22, yeah, and 23, and 24, and I think that's it. Would have done, so would have been finished. Let's move on. So Section 19, statements made by persons whose position or liability it is necessary to prove as against any party. Okay. As against any party to a suit, admissions if such statement would be admissible as against such persons in relation to such position or liability in a suit brought by or against them. Okay, this is very confusing. Let's just jump to the explanation. That is Section 19 of the Evidence Act. The language used in the Evidence Act will make you so confused. Now, the main proposition contained in this section lays down that certain statements are admissions, not that they are relevant. In the second place, that before a statement can be considered to be an admission under Section 19, there are three qualifications which the statement must have. Two of them having reference to the person making the statement or the declarant. That is, that he must occupy some such position or liability as is necessary to be proved against any party to the suit. Number two, he must be occupying such position or be subject to such liability when he makes the statement. The third qualification has reference to the nature of the statement. That is, the statement is such that in a suit brought by or against the declarant, it would be relevant as against the declarant. Okay? In relation to such position or liability. So I think this is just talking about statements have to be unfavorable to the person who is making them, and the person who is making them should be holding a position of liability. That he should be a party, okay? He should be a person who is either a party to the suit and holds a position of liability. Okay, let's say the accused or the defendant in this case. So any assessments made by them, and if they are unfavorable, okay, they are relevant against the declarant, meaning they can be used against them, okay, and make them liable. All right, so any statement made by them will be admitted as admissions, or will be admissions. Excuse me. So here we have an example to help us understand Section 19. For example, if A undertakes to collect rents for B, so Mary undertakes to collect rent for Thomas. Thomas sues Mary for not collecting rent due from Mrs. Hughes, okay? And Mary denies that rent was due from Mrs. Hughes, all right? A statement by Mrs. Hughes that she owed Thomas rent is an admission and is a relevant fact as against Mary, okay? If Mary denies that Mrs. Hughes did owe rent to Thomas. Did I confuse you more? Okay, so we have a situation where if you are a rent collector and you're collecting rent on behalf of me, okay? You who is watching this, you are collecting rent on my behalf from the from what? From, oh my god, from Galleria, okay, mall. And the manager there says if they make a statement that it's that they do not owe rent to me, okay, if Galleria manager says they do not owe rent to me, okay, that will be admitted as evidence, sorry, as an admission. It will amount to an admission because it's a relevant fact against you. If you deny that he owed rent, okay, if them, okay, oh my god, I guess I'm confusing you more. Okay, let's just say that I am the owner of Galleria Mall, and then I say there are tenants there, everyone there in the mall is a tenant, my tenant. Then you are the rent collector. I send you, please go and collect my rent because those people haven't paid for 3 months. And then you say, you deny that, no, they have paid, they don't owe me rent. Now, if the mall says indeed they owe me rent, if they admit they owe me rent, it is an admission against you because you said there's no rent due and they're saying there's rent due. All right, I think you have understood. Now we move on. Another illustration, we don't need, okay, let's just say another illustration is where A and B are jointly liable for a sum of money to C. So two people owe money to C. C brings an action against A only. A objects that he cannot singly or severally be liable and that B should be joined as a co-defendant. By being jointly liable, an admission by B to his joint liability is relevant. So where two people owe money to me and I go for one person only to pay me, and the person I go to says no, I don't have have to pay you by myself the whole amount, but then the other party says no, we admit to joint liability, that any one person that I go after has to pay the whole amount, then that will be an admission. All right, so in other words, the statements made relevant under the section are statements by persons who are not parties to the suit. So section 19 is statement of persons who are not party to the suit, but they are connected to the suit, okay? They are connected to the suit. In short, this section provides that in certain cases, the declarant may not be a part to the suit, and the sections must be read with direct reference first to section 18, which provides that a statement must be made by the persons thereafter mentioned in order to fall within the definition of an admission. And section 19 must secondly be read with reference to sections 21. So everything is connected and it flows. There's a hierarchy. So now section 20, we move to section 20, then 21, 22. I really need a break, but let's just try and keep going. So section 20, statements made by persons to whom a party to the suit has expressly referred for information in reference to a matter in dispute are admissions, okay? Yeah, we said this. This was when the accused says, ask Mr. So and so, he will tell you this, okay? Either I wasn't there or I was on holiday or he saw me at the airport leaving, so I couldn't possibly be present, all right, in the in the in the place or the scene of the crime. at the time it was committed. So under this section, when a party agrees to be bound by what a third person says or refers an opposite party to a third person for information or an opinion in a given subject, the third person's reply is admissible against the party so agreeing or referring, and if the reference has been made by agreement, it will be conclusive. So I think this is I'm thinking of alibi when you are referring the prosecution to a third person that you are with them during the commission of the crime. You are with them when the crime was committed elsewhere and you couldn't have been there. So if you refer, I think that becomes, yeah, that's the only situation I can think of right now, an alibi situation. So whatever the alibi says will be admissible. If, for example, a party to a suit agrees to be bound by a statement of a third party, such statement when made is to be treated as an admission by the party who made the offer, so that where both parties agree to refer a matter to a third party, his statement will be binding on both of them. That was in the Supreme Court of India case, Hirachand versus State of Rajasthan. The following illustration clarifies this section. The question is whether a camel sold by A to B is sound. A says to B, go and ask C. C knows all about it. Yeah, so that's it. So their camels were crazy. Is that what this means? C's statement is an admission because A expressly referred B to C. So when you refer the court or the opposing party to go to someone because they know something, they have the information you wish to rely on as evidence, then whatever information they give will be taken as an admission. All right, so now, so it says that it is very rare in criminal cases that Section 20 applies where the accused refers to another person, but it's allowed, it's permitted, but it's rare. Maybe it hasn't happened many times because really, how do you trust that the person you are referring to is going to say something that will be favorable to you? What if they say they backstab you? So it's best you rely on yourself. Now, Section 21. Subject to this act, an admission may be proved as against the person who makes it or his representative in interest. But an admission cannot be proved by or on behalf of the person who makes it or by his representative in interest, except in the following cases. So an admission can be proved as against the person who makes it or his representative in interest, but an admission cannot be proved by or on behalf of the person who makes it or by his representative in interest, except in the following cases. So it would be admissible where the person who make it was dead. Okay, when it consists of a statement of the existence of any state of mind or body relevant or in issue made at or about the time when such state of mind or body existed and is accompanied by conduct rendering its falsehood improbable, if it is relevant otherwise than as an admission. So under Section 21, admissions are relevant and may be proved as against the person who makes them or his representative in interest. Now, an admission of the opposite party to the proceeding may be produced for the purpose of proving a party's own case. It is the best evidence which can be produced in proof of the party's case, and although the proof of such admission is not conclusive against the opposite party, It is, however, a strong evidence. So where a party wants to rely on an admission, where, for example, we give the example where a suspect of stealing, all right, it's brought before the prosecution, and during his in his statement he had written that he has a habit of pickpocketing when he is hungry. Okay, so if the prosecution wishes to rely on that statement, if the prosecution wishes to rely on that statement as against the accused, okay, yeah, if the prosecution would rely on that statement, okay, against the accused to prove their own case, which is that indeed the accused was the one who stole, okay, during that day. So, what happens is the accused now will that will be admitted as evidence, okay, and the accused now has the burden to prove or to give a satisfactory explanation, sorry, that the admission was wrong. All right, so this is now talking about the shifting the burden of proof from the one who would normally use the admission to rely on it to the person against whom the admission, a to the person who made the admission. Okay, a duty is cast upon him to offer an explanation of the circumstances under which a wrong admission was made. So he has to say and to prove that no, whatever was said in the admission, maybe it was not voluntary, yeah, it was forced upon him to make, or it was a mistake, all those things. If he does not offer an explanation, the burden is not discharged. So if he doesn't, the accused doesn't offer the explanation, the maker of the statement doesn't offer an explanation to prove otherwise, the admission passes. As in, the admission is passed against him. In terms of the sections, admissions which are not based on personal knowledge are not admissible to prove a fact not within the knowledge of the maker, since a person can only admit his own acts, knowledge, or intentions, but not the acts of other persons which he has not seen and of which he can only have knowledge by hearsay. So under subsections A, B, and C, an exception applies where the maker of the statement was dead and no better knowledge of the evidence was available, or where circumstances of the statement afforded sufficient guarantees of their reliability to justify their admission. Okay, now that is hearsay. Remember, I mentioned about hearsay admissions. Now, illustrations. Okay, we have explanations here. So, okay, we have explanations. Like the question between A and B is whether a certain deed is or not forged. Is or is not forged. A affirms that it is genuine, B says that it is forged. A may prove a statement by B that the deed is genuine, and B may prove a statement by A that the deed is forged. But A cannot prove a statement by himself that the deed is genuine, nor can B prove a statement by himself that the deed is forged. Okay, how is this? Okay, I don't understand this. Let's just move on to another illustration. Okay. Now, Section 22. Oral admissions as to the contents of a document may not be proved unless and until the party proposing to prove them shows that he is entitled to give secondary evidence of the contents of such documents under this Act, or unless the genuineness of a document produced is in question. So this talks about a document. If you seek to make an admission as to the what is contained, for example, in a document, okay. Okay, so this section deals with the question as to when oral admissions as to contents of documents are relevant. When the content of the documents are provable by the production of the document itself. So that is the general rule. If you want to prove to the court what a letter says or a document says, you have to provide the letter itself. Okay. Now, this section lays down, except where secondary evidence is admissible. So where there's maybe a photo of the letter, I'm just guessing, I don't know, or a photocopy of the letter, I don't know, but let's just see. This section lays down that the content of a document cannot be proved by oral admissions unless the party proposing to give the evidence can make out a case for admission by secondary evidence. So unless they provide a secondary evidence or the genuineness or forgery of the document itself is in question. All right. So where the question, the facts and issue before a court is whether the document is real or fake. Okay, those statements can be uh, admitted. In the latter case, oral admissions of a party that it is or is not genuine is admissible if the document is produced, although such admission involves a statement as to the contents of it. Written admission of the contents of a document stands on a different footing and is admissible. Okay. So where evidence comprises the contents of a document, okay, you want to say what the letter contained. If oral evidence cannot be admissible, okay. You cannot give oral evidence as to what the letter contains. It is only in the exceptional case where such party is entitled to give secondary evidence of the content or the genuineness of that letter is in issue or is a question before the court. Those are the moments you can. Excuse me. All right. All right. So that's it about the section 22. All right. Now let's talk about cross-examination when there's an admission. How does a party go about cross-examination where there's an admission? At trial in a civil suit where a party produces documents containing admissions by his opponents, let's say the plaintiff produces a document showing an admission by the defendant, and the documents are admitted by uh, the opponent's counsel, and the opponent enters the witness box. It is not obligatory on the party who produces those documents to draw in cross-examination the attention of the opponent to the said admissions before he can be permitted to use them for the purpose of contradicting the opponent, provided that the admissions are clear and unambiguous. But where the statements are ambiguous, it is obligatory on the party who relies on them to draw in cross-examination the attention of the opponents to the said statement before he can be permitted to use them for the purpose of contradicting the evidence on oath of the opponent. So where the plaintiff seeks to rely on admissions made by the defendant in a civil suit, and the defendant is being cross-examined. Wait, I don't know, Olivia. It's very confusing. Mm, okay, I will jump this one. Now, moving on to section 23 and 24, then we are done. 23 and 24, 23 is talking about statements made without prejudice. In civil cases, no admission may be proved if it is made either upon an express condition, the evidence of it is not to be given or in question, uh, or or in circumstances from which the court can infer that the parties agreed together that evidence should not be given. That's why I said when an advocate is writing correspondences, maybe uh, maybe in a reply to an admission letter or something like that. Did I say admission letter? Sorry, demand letter. And maybe they are settling before the court moves to the before they move to court, they are trying to settle or negotiate. So any replies to the demand letter, if they contain admissions, those admissions, if they are made without prejudice, cannot be produced in court. Nothing in section 1 shall be taken to exempt any advocate from giving evidence of any matter of which he may be compelled to give evidence under section 134. So that is professional ethics and client betrayal. I call it client betrayal because what else will you call it if an advocate acts against his client's interest? So that's it. It's very short and simple. Admissions are not conclusive proof of the matters admitted, but they may operate as estoppels under the provisions here and here after content. That is section 24 of the Evidence Act. Now, this section provides that evidence is not to be adduced for communication that is made in connection with an attempt to negotiate. That is what I was saying under section 23 of the Evidence Act. But this section only applies to civil matters and not in relation to concerning criminal charges. So it will not apply to criminal trials or negotiations of criminal charges. It will only apply in civil matters. All right, that's good to know. Um, Now, under Taylor on evidence, it explains about this term without prejudice. If a man says his letter is without prejudice, that is tantamount to saying, I make you an offer which you may accept or not as you like. But if you do not accept it, the having made it is to have no effect at all. Okay, so that is basically what without prejudice means. So it has been said, do not without prejudice, as has been said, do not without prejudice mean I make you an offer. If you do not accept it, this letter is not to be used against me. So that is what it means. A number of exceptions apply to this general statement, including where the parties consent. If the party who is making the letter without prejudice consents that it can be produced in court, then it's okay. Where the substance of the evidence has been partially or wholly disclosed, where the communication included a statement that the communication was not intended to be confidential, okay, or where making the communication or preparing the document affects a right of a person. So it's okay for you to write in your correspondences without prejudice. But if it goes against a fundamental right of a person, it will not be allowed. It is the policy of the law that disputes should be amicably settled out of court, and where possible, parties should be at liberty to freely admit certain facts to facilitate or expedite a settlement, okay, without the fear of such facts being used against them in subsequent proceedings, okay. So in Katz versus Head, that is a case of 1982, Oliver Lord Oliver referred to the principle of public policy and said that the object was to encourage parties to settle disputes peacefully without going to court. This could lead to concessions for parties of peace, and this should not be treated as admissions and should not be produced in court. All right. Communications passing between parties to litigation are protected from disclosure when they contain express or implied admissions made in attempt to compromise or settle the dispute out of court, giving rise, okay, whether the attempt is made before or after legal proceedings are issued. So it doesn't matter where those communications of settlement were made, before the case went to court or after. In several cases, the parties to a matter may agree that a fact, though it amounts to an admission, may not be proved in court. At trial, for example, matters admitted on without prejudice basis for purpose of negotiations. This privilege is a rule of evidence which comes from public policy. Now, the without prejudice doctrine finds expression in this section, and being a rule of evidence, it must not be confined to discovery, nor to cases where attempts at settlement have failed alone. Now, the rationale behind the doctrine is to encourage parties to a dispute to engage in pre-trial and out-of-court settlement without fear that admission of certain facts will be used against them to their prejudice. This section therefore renders inadmissible admissions which the parties either by an express condition or by implication did not intend to be adduced in subsequent proceedings. This accords protection to any pre-trial admissions made without prejudice unless the consent of the other party or parties to it is first obtained. Three elements of without prejudice privileges are the following. There have to be a dispute, an attempt to settle the dispute has to be there, and communications containing admissions, express or implied, meant for the purpose or for a purpose incidental to the purpose of negotiation. So, not just any letter will amount to without prejudice privilege. The letter, there must be an existence of a suit. So there has to be a suit, not suit, there has to be a dispute. Sorry for that. And there must be an attempt to settle it. And those communications must contain express or implied admissions. All right, for the purpose of trying to settle a dispute, okay? Okay. So there's as for every general rule, there's an exception. So there are situations where the court can admit uh, admissions made during negotiations, and that is to ascertain whether the agreement was concluded between the parties, where the parties reached an agreement. So where the court is trying to find out if the parties reached an agreement, such a letter containing those negotiations and containing admissions will be admitted in court to explain delay or to draw or rebut inference on an application without notice. The law in this section permits to state that an admission is admissible if it is made either upon an express condition that evidence of it is not to be given, okay, or if it is made for the purpose or in the settlement of uh, a dispute to reach a compromise under circumstances for which the court can infer that the parties agreed together that evidence of it should not be given unless the party who made the admission and the party in whose favor the admission is made agree that the evidence be given. Or okay, so in order for it to be in order for admissions during negotiations to be produced in court, they have to be there has to be consent. The party who made them the admissions has to agree, or both parties have to agree. It has to be made for the purpose of okay, either that or the rights of a person are going to be disadvantaged or contravened. Okay, that was the other one we saw. What else did we see? Uh, or where certain evidence of those admissions comes to light. Part of the evidence comes to light. So that's it. We have concluded admissions in the law of evidence. We talked about what they were. We said there are judicial and extrajudicial, formal and informal. We talked about the effects it has of shifting the burden and being very serious, affecting being adverse, being disadvantageous to the case of the one who made them. We talked about them being having to be clear and concise, and they must be voluntary, they must be an acknowledgement, they have to be unfavorable. We talked about section 18 and the statements which form admissions made by an agent or a party who is authorized, made by those who hold interest or who derive interest. In persons acting as representatives. Okay, we talked that was section 18. Then 19 we said it talked about those who are not party to the suit but who are connected to the subject matter of the suit. All right, like the rent collector case, Galleria Mall case. Statement made by persons who, that was section 20. The third party who the accused refers to for information. And we said in criminal trials it's very rare. We talked about section 21. We talked about section 21 of this one was the one that was confusing. So yeah, we said it talked about the burden that is being shifted to the person, to the one who made the statement, to explain why the statement should not be relied on. Maybe it was involuntary, it wasn't clear, it was made as honest mistake, things like that. Then we talked about section 22, oral admission, as about the content of a document can only be made by a person who is in a position to provide secondary evidence, or where the question or in before the court is about whether the document is real or fake or forged, Alright, so then we moved to 23, without statements made without prejudice, and concluded with section 24, saying that admissions are not conclusive proof, but they operate as a stop base that stop people from saying facts that are otherwise. And without prejudice, we'll say that there must be a dispute and an attempt to settle the dispute, and communications have to be there which contain implied or express admissions to facts. Okay, that without prejudice can be admitted where it contravenes the right of a person, where the parties have consented, okay, or where evidence of those matters have been already disclosed. So that's it. Have a nice holiday and bye bye.